Good morning, I'm Gary DeWaal, and this is Bridging the Week for May 9th to 13th, and today is May 16th, 2016. Last week, a futures commission merchant and its controller were both named in an enforcement action by the Commodity Futures Trading Commission for their alleged failure to immediately file a notice with the CFTC when, for one night, the firm failed to have sufficient customer funds in segregation and enough of its own funds in a customer segregated account as a buffer following a clerical error. In addition, the principal financial regulator of Dubai barred a rogue trader who hid approximately $11 million of trading losses through position mismarking, while the incoming head of the UK Financial Conduct Authority identified quote-unquote hubris risk as a dangerous risk firms can only mitigate through adoption of good culture. We have a few very interesting stories to cover this week, so let's get started. Cunningham Commodities, a futures commission merchant registered with the Commodity Futures Trading Commission, and Salvatore Russo, its controller and head accountant, settled CFTC administrative charges for allegedly not immediately notifying the commission when Mr. Russo recognized the firm's failure one night to hold its required minimum amount of funds in its segregated customer account and to carry its own targeted amount of its own funds in its customer segregated account as a buffer. The initial segregated funds inadequacy apparently was caused by a clerical error. The firm also settled charges related to its alleged failure to file with the Commission required reports of its certain open positions for large traders for almost 6 months on one occasion and 2 months on another circumstance. The respondents both agreed to pay one fine of $150,000 to resolve the CFTC's enforcement action. According to the CFTC, on March 10, 2014, a staff accountant failed to transfer $5 million in loan funds from Cunningham's house account to its customer segregated account. As a result, the firm incurred a customer segregated funds deficiency in excess of $3.5 million and failed to maintain the firm's targeted amount of its own funds in segregation, namely $600,000, in excess of the firm's minimum customer segregated funds requirement. When Mr. Russo observed this error the next morning, he instructed the same staff accountant to have Cunningham's bank transfer the necessary funds from its house to a customer segregated account as of the prior business day. The bank made this transfer. Mr. Russo did not cause the firm to file notice of its regulatory breach with the CFTC or even report this matter to the firm's chief compliance officer. The following day, March 12th, Cunningham notified the CFTC of its March 10th deficiencies after being alerted on March 11th by the CME Group. The Dubai Financial Services Authority barred Noyat Ahan from engaging in financial services functions in or from the Dubai International Financial Center for allegedly hiding trading losses of approximately $11 million from his unnamed employer bank. According to DFSA, Mr. Ahan purportedly hid his losses by mismarking trading positions of his trading desk that included positions in Turkish government bonds and related swaps from April 30th to July 22nd, 2014. Mr. Ahan also colluded with brokers at various local Turkish banks to post orders on the last trading day of April, May, and June 2014 for trades in the Turkish government bonds on the Borsa Istanbul, charged the Dubai regulator. The DFSA claimed that Mr. Ahan engaged in this activity with other brokers to create closing prices that would match his month-end marks in order to avoid detection by his employer's financial management team, which, as of the last day of each month, compared independent price valuations with internal trading books' month-end marks. Under DFSA's bar order, Mr. Ahan may request a variance or revocation of his work restriction after 6 years. Andrew Bailey, the incoming head of the UK Financial Conduct Authority as of July 1st, 2016, expressed his belief that hubris risk, or the risk of quote-unquote blinding overconfidence, is among the most dangerous of risks banks confront daily, and it only can be addressed through adoption of a strong culture. In a speech before City Week 2016 conference in London, Mr. Bailey noted that there is a correlation between culture and bad outcomes. For instance, where, quote, management is so convinced of their rightness that they hurtle for the cliff without questioning the direction of travel, end of quote. According to Mr. Bailey, quote, there's not been a case of major prudential conduct failing in a firm which did not have among its root causes a failure culture as a manifested in governance, remuneration, risk, management, or tone from the top, end of quote. Mr. Bailey, who currently is Deputy Governor and Chief Executive Officer of the UK Prudential Regulation Authority, claimed that regulators can't force a good culture onto banks. However, he applauded the introduction of new senior management certification regime in the UK, which he said would make senior managers more personally responsible for the affairs of their firms. And finally, the trader in this company, subject to an enforcement action by the Commodity Futures Trading Commission in a federal court in Chicago for alleged spoofing through posting and flipping trading conduct, filed a motion to dismiss the CFTC's action on the grounds that the law prohibiting spoofing and the CFTC rule prohibiting deceptive contrivances are constitutionally vague for vagueness. According to papers filed by the defendants in support of their motion, the CFTC has never provided official notice of what activity might qualify as spoofing or be of, quote, the character of or commonly known to the trade as spoofing, end of quote. Defendants argued that, quote, the CFTC has had 5 years to rectify the vagueness for spoofing statute by issuing a rule or regulation to prohibit trading practices that may constitute spoofing, but it has failed to do so, end of quote. Defendants acknowledged that the CFTC issued a guidance and policy statement in May 2013 regarding spoofing, but said that document, quote, does not conclude that there is any common understanding in the trade of what constitutes spoofing, or set forth what that understanding might be, end of quote. Well, that's it for this week's edition of Bridging the Week. As always, there is more information in each article, and more articles on the article version of Bridging the Week on the website. Check it out. I'm Gary DeWaal. Have a great week, and until next week, ciao!